The next argument is case number 21CA0057-M, State versus Harter. Both parties are represented by counsel, so each of you will have 15 minutes to present your argument. Of course, the appellant may reserve up to 5 minutes for rebuttal. So Attorney Hall, if you would like to reserve time, let me know and I'll keep track of that. I'll also probably interrupt you to let you know that you're getting close to your rebuttal time, so you can make a decision to continue or reserve the balance.
Thank you.
You both know, I believe, that we have a rule that we do not like to use the names of victims or children. So if you could refer to them in some other way during the oral argument, that would be appreciated. I can assure you, Judge Callahan, Judge Hensel, and I have read the briefs, and we're anxiously awaiting to hear from you. So Attorney Hall, would you like to reserve time?
Yes, Your Honor, 5 minutes, if it pleases the court.
All right, and I'll let you know as you get close, but with that, you may proceed. Thank you.
Thank you. Good morning, Your Honors. Attorney Eric Hall on behalf of the appellant, Ramona Harter, Your Honors. Briefly, the facts in this case: that the appellant, Ramona Harter, was charged with domestic violence. The alleged victim in this case was her husband. There was a jury trial, and she was found guilty of 1 count of domestic violence. She received a suspended sentence of 90 days, suspended in jail, a fine, I believe, of $1,500. And in this case, she timely appealed, Your Honors. My first 2 assignments of error deal with the manifest weight of the evidence and sufficiency of the evidence. I think it's interesting to note that the alleged victim in this case, a husband, testified in trial that he was not a victim of domestic violence. He said, "I'm not a victim." And further, he stated that he did not want to pursue charges against his wife. It's also interesting to note that he couldn't really recall much about the argument that led to this incident. He couldn't recall what the argument was about. And more importantly, he couldn't recall whether he was physically aggressive toward the appellant. It was interesting to note also that at trial, he testified that he was trained in the martial arts, that he was engaged in combat sports, Both the appellant and husband were drinking, consuming alcohol, which was obviously maybe a factor in this. I believe that the alleged victim husband was drunk. He testified that he had drank 5 shots of whiskey. And a lot of times in these cases, whether it's this type of case or an OVI case, usually the amount of alcohol that's testified to, it's usually less than what's actually consumed. I know there's no evidence in the transcript, but that's just my experience. He could not recall what the fight was about. The appellant had injuries also. So the officer made a decision as to who the aggressor was, even though husband was probably a larger person, trained in the martial arts, engaged in combat sports. At trial, there was an injury that was noted at the time of the incident that actually still was at trial was a blemish. It wasn't actually an injury; it was just a blemish that the husband had at the time. That was noted as an injury at the time of the incident. Also, the appellant called 911, which is, I would argue, that's hardly the actions of an aggressor in a case. Usually, the victim is the person or a victim's family member or a friend or maybe just somebody overhearing the argument calls 911, usually not the aggressor themselves. That's rather unusual. Based on these factors, I think that clearly the court erred, or the jury erred, that the conviction was against the manifest weight of evidence. I think the jury lost their way in this case, based upon, I think the officers, they gave more credibility to the officer and his decision at the time of the incident and the scene, although he was not a witness. He did not see anything, and both the victim, the husband, and appellant testified, but they seemed to give far more weight to somebody who was not a witness, which would be the officer. They gave the officer much more credibility than they gave both witnesses, the alleged victim and also the appellant. I think that's clear. So I think they lost their way in this case. I mean, they really deferred or gave an extraordinary amount of weight to the officer, Your Honors. The next assignment of error was that the defense counsel tried to cross-examine on the issue of what the argument was about. And there was a question as to whether a husband was seeing another woman. State objected to that. That objection was sustained. I think they violated the appellant's rights under the Confrontation Clause and also under Evidence Rule 608 regarding cross-examination. Now, the argument was by the state that this was not relevant and maybe even unfairly prejudicial. But in my opinion, this could have opened up more testimony for the jurors to weigh as far as what the argument was about. There were two different versions. One, it was maybe, possibly, although they didn't get very far, that it was about husband seeing another woman or about household finances and the apportionment of household duties and compensation. If this,
excuse me, but I thought there was some cross-examination about the husband's relationship with another woman, and he denied it.
It was limited, though, Your Honor. I think that the trial court stopped further inquiry and down that road. And I think what could have happened, okay, that the jurors would have had an opportunity to weigh the testimony of both the appellant and the alleged victim husband and make a more clear determination as far as credibility. Because once again, I think in this case that the jurors, they gave so much weight to the officer or the officers involved, and very little weight, I think, to the appellant, and also to the alleged victim, the husband, who stated, "I'm not a victim of domestic violence." Okay, and that's what the whole trial was about. I mean, here's a person charged with domestic violence, and you have a victim up there stating, "I'm not a victim of domestic violence." The jurors disregarded that, and that's the only way that they reached this possible outcome was what they didn't believe husband, and gave more weight to somebody who wasn't witness, the officer. My fourth assignment of error deals with the motion to suppress. Both parties are drinking. The appellant was drinking, the husband was drinking. The appellant was sitting in the back of, I believe it was Sheriff's Deputy Cornelius in the back of the car. She had not been Mirandized yet. And then when she was Mirandized, it was obvious that she had consumed alcohol. She was Mirandized twice, which raises the issue of, if the appellant is Mirandized twice, the officer had a concern, or it demonstrates a concern whether that she understood those rights. And the argument would be that under the circumstances, without a clear waiver, okay, I mean, a written waiver of those rights, that she did not understand those rights. She was under the influence of alcohol at the time, and the trial court erred in not suppressing those statements that she made to law enforcement under those circumstances, Your Honor. Thank you.
All right, thank you. First, let me ask if there's any other questions or any questions. Judge Hensel, Judge Carr, Callahan. Okay. You'll have 5 minutes for rebuttal, and Attorney Profit, of course, you'll have 15 minutes at this point. Go ahead.
Thank you, Your Honor. May it please the court. I'm going to start with appellant's arguments in regards to manifest weight of the evidence and the insufficiency of the evidence. So there were a couple of items that were brought up by Mr. Hall. One was the fact that the alleged victim, the husband here, stated he wasn't a victim of domestic violence. First off, he never said that during the trial. What he said is that he's made no statements, no written statements, etc., about this case. That's exactly what he said. In fact, when he testified to the fact that he did suffer multiple injuries. In fact, there were exhibits that were entered into evidence that showed injuries, a bloody lip. He had abrasions on his arm. Mr. Hall does note that there was a blemish that was present the day of trial, so almost a year later, roughly. And that blemish that was noted in the original report obviously was not an injury at that time. However, you still had the injury to the arm, and you still had the injury to the lip where there was a cut. They showed video during the trial. There was testimony to both of those. In fact, Deputy Montgomery and Sergeant Cornelius both, in their direct testimony, stated that they observed the injuries that were suffered by the alleged victim the husband in this case. So there were multiple injuries to Mr. Harter. So as it pertains to the sufficiency of the evidence and the manifest weight of the evidence, it would be our contention that that's all that there was. That was the only evidence that was presented, was the fact that there was a bloody and busted up lip and an injury to the arm as well. And I believe the only testimony that we had was that Mr. Harter never struck, never choked, never physically assaulted his wife, the defendant. Further, there was some physical evidence of injury to the defendant, Ms. Harter, but in fact, those injuries were to her hand, and what would appear to be caused by striking someone. Now, as to the third assignment of error, not permitting defense counsel to cross-examine the alleged victim as the motive intent, there was, Your Honor, Judge Teodosio, as you noted, there was the opportunity to ask the question, were you seeing someone at that time? And Mr. Harter, the alleged victim, actually stated that he was not seeing someone else. Thus, that was the end of the line of questioning. Defense counsel at that time stopped that line of questioning and just moved on. As to the finances that Mr. Hall was speaking about, again, the trial court judge ruled that was not relevant to a domestic violence case. And generally, the admission of evidence is left to the sound discretion of the trial court. And the trial court decided that whatever monetary issues the family might have been having at that time was irrelevant or had no bearing on a domestic violence case. Lastly, I'll move to the fourth assignment of error. Defense counsel spoke, well, first off, let me say that, in appellant's brief, it doesn't really state which statements were looking to be suppressed. However, based on oral arguments here today, Mr. Hall points out that the defendant, the appellant, was Mirandized at one point and then made subsequent statements. However, during the trial, the video was cut off at that point, and there was no questioning done on any of those statements. Thus, I think that argument has no bearing whatsoever any weight, because one, the video, after she was Mirandized, nothing was used after that point.
So are you saying none of her statements were included in the video, just the officer Mirandizing her?
No, I'm saying there was body cam video, and that body cam video was cut off after she was Mirandized. There were arguments that there were some comments or admissions made by the defendant, or the appellant, post being Mirandized and at the jail itself. And prior to entering the courtroom, it was agreed upon that the video itself would not be shown from that point forward to the jury. And further, there was no line of questioning regarding what was stated after she was Mirandized. So that was not even a part of the case itself. That was agreed to upon by both the state of Ohio and defense counsel at that time. So as to the assignment of error number 4, I don't really see which statements or what evidence is being asked to be suppressed, because that was decided upon and addressed at trial.
So I understand you're saying there was an agreement between counsel as to what portions of the video could be shown to the jury.
Correct.
All right, thank you.
And that was cut off, and it wasn't addressed. And during deliberations, they were not permitted to see that portion. The video itself, if I remember correctly, was only permitted to be played when the bailiff was in there to make sure that wasn't done.
All right, thank you.
And as far as just to take a step back, there were some points being made about the alleged victim being a martial artist, that he was a larger man, and that, he didn't want there to be charges brought. I realize all of those things are relevant to a point. However, I don't think they have any bearing on whether or not the officers on scene decided that the defendant, the appellant, was the primary aggressor. And number two, whether the injuries were sustained, because there were in fact injuries to the alleged victim. Again, I'll reiterate, the lip, the arm, there were injuries. So as such, I think that the state, as it pertains to assignments of error 1 and 2, I believe that it wasn't against the manifest weight of the evidence, and I believe there was sufficient evidence to support the jury's verdict of guilty. As to the third assignment of error, cross-examining the alleged victim on motive and intent, I believe that was opened up. His answer was no, and that was the end of it there. The line of questioning stopped. And then lastly, as the fourth assignment of error, the motion to suppress itself, I don't think that it's applicable because the state never got into those, and those items were never presented to the jury themselves. So thank you.
Thank you, Attorney Proudfoot. Before we move on, any questions, Judge Callahan, Judge Hensel? All right. Attorney Hall, you'll have 5 minutes for your rebuttal. Don't forget to unmute, sir. There you go.
Okay, got it. Thank you. Just briefly, Your Honors. It's unfortunate that the defense of self-defense wasn't raised in this matter. Okay, but that's neither here nor there. I think there's not one single. Attorney Proudfoot points to the injuries in the case that the alleged victim husband had. He said that was really the only evidence that would support the conviction. I believe I brought up 8 points, which I believe the jury didn't consider. Okay, were the fact that husband really couldn't recall what happened. I'm just going to reiterate these quickly. He was a martial arts expert. Both parties were drinking. He was drunk. He testified he had 5 shots of whiskey. Probably had more. The appellant had injuries to her hand. Those could have been defensive injuries, but once again, unfortunately, that was not raised at the trial. During trial, a defense of self-defense. She called 911, so she called for help. There's an argument that's escalated and gotten out of control. She calls for help, so that's not the actions of an aggressor. In this case, I think the jurors just once again gave so much weight to the officer or officers that, who were not witnesses, who basically made a decision, looking at a person who apparently has maybe more injuries but that doesn't necessarily indicate that person was the victim. They could be the aggressor. And once again, at trial, husband could not recall whether he was physically aggressive during that altercation. So I would argue that the jurors lost its way, and the trial, the court, this verdict of guilty should be reversed in this case. Thank you, Your Honors.
Thank you, Attorney Hall. Judge Callahan, a question?
Yes, I do have a question. Regarding your fourth assignment of error, can you specify what statements that were admitted into evidence at the trial that you felt should have been suppressed at the suppression hearing?
Your Honor, at this point, I can't recall, though, based upon what Mr. Proudfoot has stated in his argument, if that part of the video was, if there was an agreement, and I can't recall at this point, if there was an agreement that those portions would not be played, then apparently there were no statements that would have been relevant or suppressed. I'll withdraw that assignment of error at this time. I mean, it was denied by the trial court. There's motion to suppress denied by the trial court, overruled. But apparently, at the time of trial, it was not an issue. I would agree with Attorney Proudfoot on that matter.
Okay, thank you.
You're welcome. Thank you.
Judge Hensel, anything? No? Okay. Well, thank you, gentlemen, on behalf of Judge Hensel and Judge Callahan and myself for presenting the arguments via Zoom. That's always nice to have oral argument. We enjoy it, and I think it's always good to have. So we'll take the matter under advisement, issue a decision in due course. The clerk will mail you each copy of the decision on the day it's released, and the opinions are also posted, as you know, on the Supreme Court of Ohio's website. It was a well-argued case, so thank you for that, and we hope you enjoy your day. The next